My name is Jessica Billingsley. I'm with the law firm of Church, Hiddle, and Antrim, and we've partnered with CIESC to bring you a few different trainings on Title IX. This one in particular is geared towards all employees in your K-12 school district, and with that, we'll go ahead and dive right in. Today's purpose, we're going to cover 4 main highlights. First, a basic of the new Title IX regulations that were promulgated by the United States Department of Education. Second, we're going to talk about actual knowledge. And then third and fourth, we're going to talk about 2 definitions under the new Title IX regulations, the definition of sexual harassment, and then the definition of educational program or activity. So the new Title IX regulations and actual knowledge. Most of us are familiar with or have heard of Title IX. It's been around since the 1970s. What went into effect on August 14th was new regulations that the United States Department of Education issued back in May. These new regulations set out a new process for school corporations to follow when there are allegations of sexual harassment, and we'll talk about what qualifies as sexual harassment later in the presentation. The important context for you watching this training is that the school's obligation to initiate this process is triggered by any employee in the district having actual knowledge of sexual harassment. So that means that individuals in the K-12 school world need to understand when they have to report allegations of sexual harassment and to whom they report those allegations of sexual harassment. So, the new regulations of Title IX went into effect on August 14th, 2020, and they require that a school respond to allegations when employees, any employee in the elementary or secondary school, have actual knowledge of sexual harassment. Now, one quick aside here is, what does actual knowledge mean? Actual knowledge means there's notice of sexual harassment allegations. That's a very broad term. So I'm going to make this comparison several times through this short training today, and that is that at this point, we would recommend that school employees treat allegations of sexual harassment similar to how you already treat allegations of child abuse. If you have any reason to believe or any notice that there are allegations of sexual harassment, that you make that report to your Title IX coordinator. So that's the largest takeaway I want you to walk away with today. The second thing, you might have heard me refer to a Title IX coordinator. If you do not know who your Title IX coordinator is within your district, then that's your homework from today's short session, to go to your district administrators and figure out, or maybe just your building administrator, and figure out who your Title IX coordinator is, because that's the person you will need to make sure receives information about these allegations of sexual harassment that you come to know about. What is the actual definition of sexual harassment? And before I get into the definition, I do want to clarify something. We're providing these definitions so that you understand what to be looking for and keep your antennae up for. It does not mean that you, as a district employee, need to make a determination on the spot of whether or not the allegations you receive notice of actually qualify as sexual harassment. That's something that can be left up to the Title IX coordinator. The purpose of these definitions is to give you a better idea of what qualifies as sexual harassment under the new regulations issued by the United States Department of Education. That parallel, again, to reports of child abuse and neglect. Under those mandatory reporting laws, you know that you are immediately to report. You are not to do any sort of investigation to determine if there's actually child abuse happening. Similarly, we would advocate that you not try to investigate or look into allegations of sexual harassment you hear about, or try to determine if they fit in one of these 3 definitions of sexual harassment. Rather, we would urge you to make the report to your Title IX coordinator and have them make those determinations, because we're issuing a series of these trainings, and one of those trainings is geared towards those Title IX coordinators. It's much more in-depth and gives them the tools to make these determinations about what actually qualifies for sexual harassment. So with that caveat, we'll go into what the different definitions are under the new regulations. The first definition we're going to refer to it as sexual harassment type 1, is conduct on the basis of sex that satisfies one or more of the following. And the first one is a school employee conditioning the provision of an aid, benefit, or service of the recipient on an individual's participation in unwelcome sexual conduct. This is known as quid pro quo. You might have heard something for something else. It's essentially a school employee exchanging good grades or not having to take a test or anything along those lines for unwelcome sexual conduct. That's pretty clear and should already be on your radar. Maybe less clear is the second definition of sexual harassment, and that is unwelcome conduct determined by a reasonable person to be so severe, pervasive, and objectively offensive that it effectively denies a person equal access to the recipient's education program or activity. So this essentially covers things that are not necessarily physical, but verbal or electronic forms of sexual harassment. I will note that it uses the standard of a reasonable person, so put yourself in the shoes of a reasonable person, and that it has to be severe, pervasive, and objectively unwelcome. Those things just mean that they're from the perspective of somebody third party who's not interested in the events. And again, I say that with giving you this knowledge does not mean that you should be trying to determine whether or not the allegations you're aware of fit into one of these three buckets. Instead, you have a general understanding that it's something severe, it's something pervasive, and it's offensive, and it prevents that student or possibly employee from accessing your district's education program or activity. The third type of sexual harassment is actually 4 more definitions. So we have sort of these two more, you have the quid pro quo as the first type, which is very specific, and you have an amorphous second type of sexual harassment, which is the severe, pervasive, or objectively offensive. This third type is meant to capture anything that the United States Department of Education and Congress, in some of its other laws, determined is bad enough that even if it's not pervasive, it's not happening more than once, it's severe enough that it should trigger these new regulations and this new process under the Title IX regulations. So the third type of sexual harassment is sexual assault, as that's defined by the Clery Act. You might have heard of that act before. It's passed by Congress and defines all sorts of different things related to campus security and campus statistics. This is new as it's applied to K-12 education realm because that Clery Act typically only applied to post-secondary institutions. So sexual assault is defined there, but if anything rises to the level of sexual assault, it will certainly qualify to trigger the obligations under the new Title IX regulations. The second one is dating violence, and this one, along with the 2 other final definitions, are all from the Violence Against Women Act, or sometimes you'll hear it referred to as VAWA. And they're each defined there, and each of them will qualify as sexual harassment that should trigger a report under the new Title IX regulations. So dating violence, domestic violence, and stalking are each included in the definition of sexual harassment under these new regulations. So we've gotten through the definitions for sexual harassment. The definition of program or activities may also come into play when determining the report of sexual harassment. So the Title IX regulations only apply when it is a program or activity of a recipient of federal dollars. So what that means and what that includes are locations, events, or circumstances over which the school exercises substantial control. The school also controls the individual who's accused of sexual harassment. You might hear them referred to as the respondent. It also is limited to people and places in the United States. So it may not necessarily apply if your district has an exchange program and students are abroad at that time. It doesn't mean you can't address it through other rules of conduct or student handbooks that you may have. It just means that these Title IX regulations may not apply. I give you this definition again. I will give you my caveat that if you are in doubt, on my last substantive slide, we'll say this again, Don't question whether or not it happened at a location, event, or circumstance over which the school had control. If you have knowledge about it, report it to your Title IX coordinator, and they can make that determination if it's more or less within the school's jurisdiction or within the bounds of these new Title IX regulations. Because it is possible that events that occur at a non-school event, after school hours, or on a weekend may still come within the context of these new regulations. But primarily, you should be thinking about things that are school-sponsored activities, obviously during the school day, or other times when it's obviously a school program or activity where these allegations are going to be the most important to report them. As promised, my last substantive side is when in doubt, report to the Title IX coordinator. So much like DCS reports, when in doubt, report to DCS. The last piece I wanted to point out is that oftentimes you will have an overlap between allegations of sexual harassment and potential child abuse or neglect. And in those instances, know that your report to the Title IX coordinator does not absolve you of the report to DCS. And in fact, due to the immediate language in the statute regarding reports of child abuse or neglect, that report to DCS should be made first before you report it to your Title IX coordinator. So keep in mind that while I talk about these things like they may be separate, it's also entirely possible that they overlap and you may have reporting obligations under both laws. So this has very much so only touched the tip of the iceberg of the new Title IX regulations. For context, the Department of Education issued over 2,000 pages of notes explaining the regulations, which in total are only 27 pages. So there's a lot of information out there to digest. CCHA has already taken a lot of that on and produced several of the materials that you or your district may need. So we do have what we call the CCHA Title IX Toolkit that includes template procedures, notices, we have a flow chart, we have these and other basic training slides, and we also are happy to work with you or your district to provide recorded or live training. So with that, I will leave you with my contact information. If you have any questions on what we've presented or would like to touch base with us on any of the toolkit items discussed above, feel free to reach out to me or any of my colleagues in the CCHA School Law team. Thank you.